Next topic is intellectual property. What is it? And these are not just pictures for entertainment purposes. Each of these represent a type of intellectual property. And we'll go through each of these so that you'll understand what these are and why they're protected and how to protect them, or if you want to protect them. First, patents. So this is the one that's most commonly thought of when we think of intellectual property, and they are inventions. Inventions mean that nobody else has come up with this before. Now, it doesn't mean that no one's invented this particular thing. It could also be an application of the thing, right? For example, you could have created a new food called Nutella, and you could, if you wanted to, patent Nutella. But somebody else may figure out that there's a clever use of Nutella waxing a car. So it takes out the grit, takes out the impurities in the oxidation of paint on a car. Well, that could be patented. So a novel use of something that is existing can, in certain circumstances, be patented. So it's not just the invention of a thing, it also relates to the application or use of the thing, all right? But most of the time it's an invention. And a light bulb is a good example that could be patented. And atorvastatin, which is a long name for Lipitor, the most profitable drug in history, is Lipitor. So you could see on the left side the patent number 223,898, which is a lot of patents because that was years ago. Cannot be from a company. The rights can be with a company, but it is only granted to the inventor, a person. In this case, it's Thomas Edison who received the patent. He in turn assigned the rights to the company he formed, General Electric. On the right side, Lipitor, that's a chemical compound that has earned $131 billion for Pfizer. So that is a formulation of a drug. This is why pharmaceuticals are so profitable, because a blockbuster drug is worth billions of dollars if it cures a common ailment. All right, so that's a patent. So what are the types? Utility is an invention. It's mechanical, general, or chemical, but not necessarily an idea. There's a physical form or process. So those are utility. These are the most common patents. Design is appearance. This could be sports uniforms, electronic products, but in the example here is the face of a watch, an Apple Watch. Third is patent patents. There's specific rules related to genetically modified plants. I know that's not necessarily in good favor, but there's a whole body of law protecting who comes up with the genetic modifications to plants. And finally, business methods. This is more of how things are done, and this is computer code, technology, logistics systems, things of that sort are covered by business model patents. So these are the four broad forms as provided for in the U.S. patent law. Next is a trade secret. Trade secret, as the name implies, it's a secret, which means they're not going to tell anybody about it. The one thing bad about patents is you must file for a patent, and in that filing, describe how your invention works, such that somebody who is knowledgeable in your field can take just what you put in the patent application or approved patent and replicate what you do. So you can't just be kind of shifty about it and not give a critical ingredient. You must give it so that it bears the invention and how it works. So why would you not do a patent? They expire. The first example here is Coca-Cola. If Coca-Cola patented their formulation of the Coca-Cola soft drink, they would go off patent, and then all of a sudden everyone can make Coca-Cola. We sit here hundreds of years after the invention of the drink, and we still can't replicate exactly how to make a Coca-Cola. Trade secret does not have a limited life, and you can keep it a secret as long as those who know it keep it a secret. And there are other examples, such as Foxconn. In Foxconn, they manufacture very efficiently all kinds of electronics, watches, computers, laptops, etc. And much of their intellectual property is how do they do it? How do they do it so efficiently and effectively? You can't go into some of these very highly sophisticated manufacturing plants with anything on your body that can shoot a picture or shoot a movie, because those are their intellectual property. How do they manufacture so efficiently? So these are two examples of trade secrets. One is a formula, like a recipe, and the other is a methodology like Foxconn's manufacturing capabilities. Next is a trademark. So the trademark is interesting because it is something that is recognizable, that has brand value. And the first is the Nike swoosh on the left. You've seen it 1,000 or 1,000,000 times. And so even without the word Nike, if you just saw the swoosh, you'd know it's Nike swoosh. Just if you saw the word Nike, you'd know it's not some other Nike, but the athletic company, apparel and shoe company of Nike. The right one is more interesting. So if I make the following sounds, doon, 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 those 4 tones, some of you, assuming you can recognize my bad singing, those 4 tones represent Intel. They did an advertising years ago when you made those sounds, doon, 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 they put Intel inside, differentiating that this computer, you can't see the motherboard, but on the motherboard is an Intel microprocessor. And somehow that makes it better than another microprocessor, say from AMD, Advanced Micro Devices. 4 sounds could indicate a trademark or a sound that indicates Intel, and it means a branding message. So branding could be through a drawing like the swoosh, or a font or depiction like the word Nike, or a set of sounds like the case of Intel. Next is copyright. Here it's some intellectual creation. It's a writing not only of words, but also electronically formed things such as computer code. So here we have Stairway to Heaven, which is the theme for our class, which is music, obviously. Novels are creation. They're creative writing that is done by an author. Computer code is a creation of code that is a personal creation and therefore patentable. And any writing, if you wrote a manual to your company's product, that can be copyright. Any original work. Your work for homework is potentially something you can copyright. So back on the pros and cons of patents, since it's such an important consideration. First, it gives you competitive advantage, or we believe it could. That is an enforcement of the right. But when you file it, it could be a disadvantage because now people know how you do it, and they might try to squirm around your invention and get something that's close, but not something where you could sue them that they've stolen your invention. So by giving details, you may be giving up a little bit too much. Next is the advantages. Funders love patents because they believe that it creates a competitive advantage to the company that no one can just copy it. The negative is, again, somebody who's clever can get around it. All of a sudden, that investor will not be happy because someone made what we call a knockoff or a copy of that particular invention. Next is that there is protection for 20 years, so no one can use your invention for that period without your permission, which means that you can sell the use of your patent to somebody else so that they have permission from you, but they must pay you for it. So that's the advantage. The con is the same. It's 20 years, which means beyond 20 years, it is now what we call in the public domain. So if Coca-Cola or Mrs. Fields Cookies have put the recipe in a patent, after 20 years, we would all know how to make the perfect chocolate chip cookie or how to make Coca-Cola. So what is the process like to get a patent? Well, the first thing to remember is don't talk about it, because if you do, it may be seen as part of the public domain and no longer your invention. It's only an invention patentable if it's a secret, so don't tell anyone about it. Hire an attorney. I know they're expensive, but it's a specialty that someone you know, your family friend who's an attorney, is probably not a patent attorney or expert. So get an expert or it will be done incorrectly and you just waste money because it will have no good effect. They will do a patent search to make sure you're not fooling yourself. Did you really invent something, or did somebody else invent it and you just didn't know? That happens all the time, as you might imagine. So a patent search is done to assure everyone that this is indeed something that has not been done before. Next is you want to know which country do you want to file in. Unfortunately, there's no international patent office. Does not exist. And so if you want to be patented in the US, you file in the US. If you want to be patented in France, you patent in France. If you want to be patented in Japan, you patent in Japan. The expenses could get pretty large, so you have to be very thoughtful about which countries you want to have patent protection. The process itself in the US, you would file what's called a provisional patent. It's very important to know what this is, because once you file a provisional patent, you have marked that date and time as when you invented it, or at least in the eyes of the patent office. So anyone who's subsequent to that wants to file on that idea, they cannot, because when they do a patent search, they'll see that you beat them to the punch. So a provisional stops others from taking the idea. It needs to have sufficient detail so that you can start the patent review. It may not be the final filing, it probably is not, but you want to make sure you mark it and be ready to respond to the inquiries and requests of the patent office. From that point on, you get to put patent pending. You've seen it on products all the time, patent pending and some number. That means that you're in the process of getting a patent. Again, deterring people from just copying your idea and conveying to investors and customers that you have something unique that's worthy of a patent. Then you would take time to respond to the questions from the patent office, and you'll get roughly a year when they respond to you. And then through iterations of conversations and filings, you will then get a granted patent, and then the clock starts. All right, so how do you try to protect with your employees and contractors? This is very important considerations for many reasons. First is that it protects the company from someone inside stealing the idea. So what we do is we create what are called confidential disclosure agreements, and it means that every employee who signs this cannot use what they see inside outside for their benefit or for their friends' benefit. And these could be how you do things, customers, financial information, anything that is deemed company information that cannot get outside. You're protected from your employee from doing so. If they violate it, you can have all kinds of remedies. Maybe the damage is already done, but at least you can have some protection. We can sue your employee. Next is in the employment contract, you would have general terms, salary, vacation, things like that. And then you'll also have typically what's called a proprietary inventions agreement. So this is furthermore that if it's an employee who happens to create something, computer code or some hardware product invention, it is owned by the company. So they can file a patent in their own name, but the company owns the rights to that invention. Again, an individual must be the person who gets the patent, but if that individual has signed away the rights to their invention to the company, then as a second stage, the company would then get an assignment of all the rights and privileges of the patent from the inventor. So if you join a company, you came up with some amazing invention, you would be forced by the terms of your employment agreement to sign over those rights to your company. So some more lingo. So we have other lingo like articles of incorporation. These are the filings you do to the Secretary of State in the United States. States have the right to grant corporate status. So articles of incorporation kind of give the rules of how the company will be run and the purpose of the company, etc., filed with the Secretary of State in California or Massachusetts, or wherever you choose. Confidential disclosure agreements, these are for anybody that you work with, could be an employee or a contractor, to keep your secrets secret. Next are copyrights, the form of IP related to a creative invention that you write, like music or a novel. Corporate bylaws are the laws, are the rules under which the company will be governed. It usually states the limitations of the rights of management and the board, and also kind of gives other rights for circumstances, like if you want to sell your stock. Corporate charter, these again are filed with the Secretary of State, which is largely legalese to form that you are adhering to the rules of the state and U.S. law. Corporation is an entity type, which is the most common one, which has the advantage of legal liability protection, but the disadvantage of double taxation. Employment contract, this is to employees limiting their rights and specifying expectations. IP is the general term related to different forms of intellectual property, which are inventions or things that have value. Joint and several, this is the characteristic of a general partnership where one partner is not only liable for his or her share, but could be found to be liable for all the share of all the partners. Limited liability is how we can limit what you can be sued and found liable for as a person. LLC is a type of corporation typically used for professional organizations where the managing members are both workers and their owners. There are other uses of LLC, but that's the common one. Limited partnership is similar to a general partnership, except there's only one GP, and the limited partners can only lose the amount of money that they put in. Partnership is just a general form, that general term, meaning people get together to do something together. And in the absence of other specification, it is a general partnership. So partnership is a very open term, but if you don't qualify it otherwise, you're deemed to be general partners. Next is the agreement. This is the agreement specifying the rights and privileges and rules by which a partnership is run. Patents, we already talked about, is legal protection granted by a country for intellectual property and its use in that country. Proprietorship is an individual opening their own business in their own name or a DBA. An S Corp is a type of corporation which is meant to be for small businesses to help them get started, and it has tax benefits. Namely, there is no corporate tax. Trade secrets are things like the Coca-Cola recipe or the methodology used by Foxconn to make a laptop computer. Right? Those are trade secrets that you control by keeping a secret without any filings. Trademarks are things you do file that convey your brand, like the Nike swoosh, like the Intel sound. And finally, unlimited liability means that every owner has personal liability with no limits. And that's the characteristic of a general partner. So that's more venture lingo from this particular chapter. So summarizing what we've done for video 1, session 1, we looked at the principles of entrepreneurial finance, and we looked at renting resources, rate of return, cash is king, the unique nature of financing as a private entity, the group objective of creating shareholder value or value of the organization, and know that people, although we wish that they would think on behalf of others or the company good, they will most often or many times consider their personal self-interest, and that character and reputation matter. So if you think you can talk fast and fool somebody, you might be able to fool someone once, but probably not very often. Next, we looked at the stages of financing from seed all the way up to maturity. Then we looked at, in this particular video, chapter 3, on the legal forms that you can choose to start your business, and also the very important topic of intellectual property, the different types, how to protect it, and why it's so important. So we're off hopefully to a quick and good start, and I'll see you guys in class on Tuesday.